Hey guys, welcome back to the channel. This is the House of Law and I am Attorney Al Jumrani. This is episode 9 of Civil Law Jurisprudence by Justice Leonen, our second to the last in this series. So if you missed the 8th episode, you can watch it through the link above or the link in the description box below. So in this episode, I will talk about 3 more Supreme Court decisions penned by Justice Marvick Leonen. The first case is about compromise judgments. The second case is about contracts entered by one without the authority of another. And the third case is about divisible and indivisible obligations. So let's begin. Our first case is Chiquita Brands versus Omelio, GR number 189102, June 7, 2017. So in August of 1993, a class suit was filed in the United States by thousands of banana plantation workers worldwide against 11 foreign corporations. Among the plaintiffs there were Filipino workers who sued Philippine-based corporations like Dow Chemical Company, Dole Fresh Fruit Company, Del Monte Fresh Produce, and Chiquita Brands. The class suit stemmed from the use by these corporations of dibromochloropropane, or DBCP, from the 1970s to the 1990s. This pesticide, meant to kill roundworms and threadworms, were found to cause sterility to human beings who were exposed to it. The United States courts, however, dismissed the actions on the ground of forum nonconvenience and directed the claimants to just file their actions in their respective home countries. So because of that, the Filipino workers filed a complaint for damages against the Philippine-based corporations before the Regional Trial Court of Panabo City, Davao del Norte. The case was docketed as civil case number 95-45. Meanwhile, back in the US, the parties in those cases entered into a worldwide settlement called Compromise Settlement, Indemnity, and Hold Harmless Agreement, whereby the claimants were to receive varying amounts of indemnity in exchange of their not pursuing legal action. The settlement amount would be deposited in escrow to be administered by a US-based mediator and to be released to the claimants after they have executed their individual releases. So the parties in civil case number 9545 presented the compromise settlement. On the basis thereof, the RTC of Panabo City issued a judgment based on a compromise. So the judgment became final and executory. However, not long after, several plaintiffs moved for execution of the judgment, demanding that they be directly paid by the defendant corporations. This was opposed by the defendant corporations on the ground that the manner of payment was laid down in the compromise settlement, which was approved by the court. That is, the indemnity would be placed on escrow and that the claimants only have to execute individual releases for the US mediator to give them their checks. But despite the opposition, the trial court issued the writ of execution. So the issue in this case is whether the judgment based on the compromise can still be modified in its terms and execution. The Supreme Court declared that the writ of execution is null and void. A compromise is defined under the Civil Code as a contract whereby the parties, by making reciprocal concessions, avoid a litigation or put an end to one already commenced. It may either be judicial or extrajudicial, depending on its object or the purpose of the parties. A compromise is judicial if the party's purpose is to terminate a suit already commenced. On the other hand, a compromise is extrajudicial if its object is to avoid litigation. In any case, a compromise validly entered into has the authority and effect of res judicata as between the parties. To this extent, a judicial compromise and an extrajudicial compromise are no different from each other. However, unlike an extrajudicial compromise, a compromise that has received judicial imprimatur becomes more than a mere contract. A judicial compromise is regarded as a determination of the controversy between the parties and has the force and effect of a final judgment. In other words, it is both a contract and a judgment on the merits. It may neither be disturbed nor set aside except in cases where there is forgery or when either of the parties' consent has been vitiated. The doctrine of immutability of judgments applies to compromise agreements approved by the courts in the same manner that it applies to judgments that have been rendered on the basis of a full-blown trial. Thus, a judgment on compromise that has attained finality cannot be modified in any respect, even if the modification is meant to correct erroneous conclusions of fact and law, and whether it be made by the court that rendered it or by the highest court of the land. The second case is University of Mindanao versus Bangko Sentral ng Pilipinas, GR number 194964-65, January 11, 2016. In 1982, University of Mindanao's former Vice President for Finance, Saturnino Petalcorin, executed 2 deeds of real estate mortgage over University of Mindanao's properties in Cagayan de Oro and Iligan City in favor of Bangko Sentral ng Pilipinas to secure the loan obligations of First Iligan Savings and Loan Association and Davao Savings and Loan Association, both of which were owned by Guillermo B. Torres, the former chairman of the University of Mindanao's Board of Trustees. Saturnino Petalcorin was supposedly authorized by the board through a board resolution and a corporate secretary certificate signed by the corporate secretary, Ms. Aurora de Leon. So the loans matured in 1999, but then the loans were not paid. Thus, Bangko Sentral ng Pilipinas sent a letter to the University of Mindanao informing it that the bank would foreclose University of Mindanao's properties in Cagayan de Oro and Iligan. In its reply, the University of Mindanao administration denied that it authorized the mortgage and that it received any loan proceeds from the Bangko Sentral ng Pilipinas. According to the University of Mindanao, Saturnino Petalcorin and Aurora de Leon signed the deeds, the board resolution, and the secretary certificate only because they were told to do so by Guillermo Torres. So the issue in this case is whether University of Mindanao is bound by the real estate mortgage contracts executed by Saturnino Petalcorin. Here, the Supreme Court held that the mortgage contracts do not bind the University of Mindanao. The trial court and the Court of Appeals found that the secretary certificate and the board resolution were either non-existent or fictitious. As a corporation, the university must exercise its powers and conduct its business through its board of trustees. It may, however, delegate through a board resolution its corporate powers or functions to a representative, subject to limitations under the law and the corporation's articles of incorporation. Article 1317 of the Civil Code provides that no one may contract in the name of another without being authorized by the latter, or unless he has by law a right to represent him, and that a contract entered into in the name of another by one who has no authority or legal representation, or who has acted beyond his powers, shall be unenforceable, unless it is ratified expressly or impliedly by the person on whose behalf it has been executed before it is revoked by the other contracting party. Be that as it may, the Supreme Court held that personal liabilities may be incurred by directors who assented to such an authorized act and by the person who contracted in excess of the limits of his or her authority without the corporation's knowledge. Our third and last case for this episode is Spouses Lam versus Kodak Philippines, GR number 167615, January 11, 2016. So in this case, the Spouses Lam and Kodak Philippines entered into an agreement for the purchase of 3 units of Kodak Mini Lab systems to be installed in the 3 stores of the Spouses Lam, first in Rizal Avenue, the second in Tagum, Davao del Norte, and the third in Cotabato City. The price per unit was 1,796,000 pesos. According to their agreement, the Spouses Lam were to issue 48 post-dated checks in the amount of 35,000 pesos each. So Kodak was able to deliver just 1 unit and it was delivered to the store in Tagum. Meanwhile, the Spouses Lam were only able to pay 2 monthly installments. Kodak was not able to deposit the succeeding checks because the Spouses Lam instructed the drawee bank to stop payment. Because of this, Kodak sent a letter to the Spouses Lam rescinding the contract due to non-payment. Also, the Spouses Lam sent a letter to Kodak telling the latter that they were rescinding the contract due to failure to deliver the other 2 units. They claimed that the reason why they stopped the payment of the checks was Kodak's failure to deliver the remaining 2 units. So to this, Kodak claimed that the obligation was divisible and that the Spouses Lam were obliged to pay in full the first unit before the other 2 units would be delivered. Kodak then filed an action for replevin and for sum of money. Kodak was able to seize the unit from the Tagum store, and in addition, it mistakenly took a generator which the spouse's lamb purchased from another supplier. Both the trial court and the Court of Appeals ruled for the rescission of the contract. However, Kodak was ordered to reimburse spouse's lamb the value of the generator as well as varying amounts for actual, moral, and exemplary damages. The main issue in this case is whether Kodak's obligation was divisible or indivisible. The Supreme Court held that based on the agreement of the parties, the intention was for there to be a single transaction covering all 3 units of the mini lab equipment. Kodak's obligation was to deliver all products purchased under a package, and in turn, the spouse's lamb's obligation was to pay for the total purchase price payable in installments. The Supreme Court cited Article 1225 of the Civil Code and emphasizing the last paragraph. Article 1225 of the Civil Code states that for the purposes of the preceding articles, obligations to give definite things and those which are not susceptible of partial performance shall be deemed to be indivisible. When the obligation has for its object the execution of a certain number of days of work, the accomplishment of work by metrical units, or analogous things which by their nature are susceptible of partial performance, it shall be divisible. However, even though the object or service may be physically divisible, an obligation is indivisible if so provided by law or intended by the parties, like in this case. Alright guys, those are the 3 cases for this video, and that caps episode 9 of Civil Law Jurisprudence by Justice Leonen. Watch out for the last episode of this Case Digest video series. I hope may natutunan kayo today. For the bar reviewees, take note of these cases baka lumabas sa bar this November. Please drop a like if you like this video. Please subscribe to support me and click that notification bell to be alerted when I upload a new video. So till the next video, laging tatandaan, isip ay buksan, alamin ang batas. Bye guys.